You know,
Yeah.
Mike, the big thing, and we've said it, we've said it ad nauseum, is that in regards to Miranda being read, it is in custody plus interrogation equals Miranda. When was the exact time that Luigi Mangione was clear to him or any other reasonable person that he was not free to leave, and not just not free to leave, because that doesn't signify you're under arrest, because while the police are conducting an investigation, you're not free to leave. That's clear. And some cops make a mistake of saying that the guy was free to leave when he clearly wasn't. No, you're on the stand. No, he's not free to leave until I complete my investigation. And many times, a suspect, once I complete my investigation and I determine he's not the guy, I let him go. So that's the correct answer. So in custody plus interrogation equals Miranda. When was he in fact in custody and under arrest? And was he interrogated? All of those things must be present. So all the TV stations are jumping on the defense attorney. So they searched him without a warrant. They didn't read him Miranda. They don't know the law. They're just repeating things like a parrot. Mike.
Yeah, when you have like a Terry stop, we've talked about this, the Berkemer versus McCarty case. There's no need. It's not the kind of stop that's a more permanent stop where you don't know that if charges are going to come in the future. Car stop on the side of the road for speeding, that's a Terry stop for highway officers. In this case, that sort of Terry stop, the Supreme Court has said 40 years ago now, that does not trigger the need for Miranda. Once you put the bracelets on the guy, that's a different story. Now you stopped him. You're now intending to charge him with a crime. You're seizing him. You're putting the handcuffs on. At that point, you should Mirandize him and let him know what his basic constitutional rights are. And then you should only have one. If you're going to have a uniformed officer there asking him questions, there should be just one officer asking a few questions, but you want to get that person back to the station house as fast as possible. Do not say a word to him. Get him into the detective unit squad room and hand it over to the catching detective. And together you do that. But that's when Miranda is triggered, when you got the custody. Plus, if they start asking him in what they call interrogatories, statements that if the answer to which would lead them to believe that he's involved in a crime, that would implicate him in a crime. But there's in this case, okay, we could talk about maybe some of the police, they had 18 cops there, or whatever, or it was overkill, whatever. But the fact is, what they did was perfectly lawful under the Fourth Amendment. And just think about it. Even if they got rid of all of this evidence, you still are going to have that hostile clerk, that female hostile clerk in Manhattan who saw his face. You have that I think the livery cab driver that saw his face in his rearview mirror who may do an ID. You've got the backpack and information that was left in that backpack that was left in Central Park. You have that. If you can get any of his previous so-called friends, you do a search of their laptops, or ask them to come in and consent to a search of their laptop. And if there's any incriminating evidence off those laptops, that may be used. There is still evidence out there, tremendous evidence out there, that points to him being the shooter. I mean, this case it's got all kinds of great information, both follow-up detective work, great detective work, but also great police work, uniformed police work that we're talking about now. So it's a fantastic case. And professors and other people who do instruction in criminal justice, rookie cops should use this as a training tool.
100%. Mike, a quick story. When I was on the job, we picked up a double murderer in the Bronx, and at 3 or 4 in the morning, and we knocked on his door.
Time.
We knocked on his door. We said, "Listen, we need to talk to you. Will you come with us?" He gets dressed and he comes with us. He doesn't ask a single question as to why he's being brought in, and we don't offer.
No.
We put him in the car. None of us talk to him or say a single thing. We get him into the 2-3 detective squad in Manhattan. We let him know why he's there. We read him Miranda, and he makes a full confession to a double murder implicates his. But the point was, when a defense attorney gets one of those detectives on the stand and says, "What did you talk about on the way to Manhattan?" Nothing. We didn't say a word to him. They'll find that hard to believe, but that's what a professional detective does. We didn't ask him, was he in custody? No, we didn't. He wasn't even cuffed. We asked him if he would voluntarily come in, and he did. That turns defense attorneys up. But that, if you can do it, and I'm not saying you can do that in every case, because sometimes a murder suspect is extremely dangerous, and you don't want to ride from the Bronx to Manhattan with him in the back seat. So, Mike, I think this was fascinating, and I really, these hearings are going to be fascinating, and what happens here, the judge is going to make a decision based on the law, based on case law, but I believe he will throw some crumbs to the defense, but I think he's going to allow the most significant evidence. And Mike, very quick, your last thoughts, very quickly.
Yeah, I think people should, who aren't in law enforcement, should, review this and look at the tapes and listen to the show, because it's a primer on the Fourth Amendment and how police conduct, dangerous investigations. And I think the police did a great job here. So thumbs up to Altoona, Pennsylvania. I
agree. There's just, I'm saying, if I had my druthers, I would wish they had done it this way. But I agree. They did a fantastic job. Folks, thank you so much. I'm Bill Cannon from Police Off the Cuff. On behalf of myself and Professor Mike Geary, thank you so much for tuning in. We'll see you soon. Have a great day, everyone. One episode just ain't enough.